Good afternoon, everyone. Myself, Shreya Arora Mehta, welcome you all to the session 2 of Delhi State Legal Service Authority Learning Series. The session for today is on interplay between mediation, conciliation, and Lok Adalat under the Legal Services Authority Act 1987. Before requesting the learned resource person for today, I would request our learned member secretary, Mr. Kawaljeet Arora, to share his vision on the topic for today. Over to you, sir.
Good afternoon, friends. I hope you all are doing well. So, as Shreya said, welcome to the second session of this learning series of Delhi State Legal Services Authority. So, topic for today's discussion is interplay between mediation, conciliation, and Lok Adalat under Legal Services Authorities Act. Friends, let us recall the last session, which we did on commercial litigation and force majeure. That was in the context of the present day scenario, which all of us are facing, that is scare of coronavirus. Friends, we all know that to prevent the spread of this virus, central government has declared national lockdown, which has had its resultant impact on the economy. As a result of this national lockdown, earning capacity of the persons has gone down because of less or practically no business. Consequently, as you all know, that in estranged marriages, husbands are not in a position to pay maintenance to their wives, tenants are not in a position to pay rentals to the landlords, and borrowers are not in a position to pay interest to the banks. You would remember that in the last session also, it emerged that legally speaking, the maintenance, rentals, or interest, they cannot be waived. But all such factors, all such disputes, we can resolve using humanitarian approach, that is through out-of-court settlements. And here comes the role of alternate dispute resolution. Friends, as you are associated with us with legal services authorities, Chapter 6 and 6A of Legal Services Authority that speaks about it. So does Section 89 of Code of Civil Procedure. You all know that traditional dispute resolution or the litigation refers to the proceedings before a court of law, whereas these alternate dispute resolution methods, they are more flexible, they are more party-centric, which includes negotiations, mediation, conciliation, and arbitration. The need of these alternate dispute resolution is not only to reduce the burden of the court, friends, but also to create a sense of participation in the transacting parties in dispute resolution process. जब वो खुद इन्वॉल्व होके अपना जो भी डिस्प्यूट है वो रिजॉल्व करते हैं, they feel that they themselves are the winners. In traditional process, a judge who is an outsider, he pronounces a verdict with respect to dispute between the two parties, which generally doesn't go well with one of them, and there is always a heart burning of one of the parties. Whereas in the settlement process, be it through mediation or Lok Adalat, both the parties they emerge as winners. Both feel that they themselves have arrived at a consensus to resolve their disputes. Here I would like to say that जैसे हम बात करते हैं that these days we are shifting towards alternate dispute resolutions, I'll say that we are not evolving it, rather we are re-evolving it. This process was very much there in our system, in our culture, in our heritage from times immemorial. Aajkal, during this lockdown period, Delhi Doordarshan has say re-telecasted Ramayana. I would recall a recent episode which was shown in Ramayana. आप सबने भी अगर देखा होगा, जब राम और रावण का युद्ध जब लंका में चल रहा था, and Kumbhakarna and Atikai, they were executed in that battle. So at that point of time there was a samvad between Mandodari and Ravan. अगर आप उसको recall करें, Ravan said, Mandodari was telling Ravan that Ram is Vishnu's avatar. So Ravan said कि what if अगर वो मेरे को मार भी देगा तो he is not going to gain much, rather it is me who is going to gain much. He has taken a stand taken a stand because of probably the weapons he acquired, पूजा करके अपनी बाहों के बल के ऊपर. But Mandodari said that, isn't it possible that both of you emerge as winners, दोनों साइड जीत जाएं, आप सेटलमेंट कर लें, सीता को बाइज्जत आप राम के पास छोड़ आएं. So that was a process, that was a thing, that was an initiation from Mandodari even at the time of Ramayana, of settlement, of resolving the dispute amicably. अगर let us now dig into महाभारता. महाभारता में भी आप सब जानते हैं कि कौरव और पांडवों के युद्ध से पहले एक सेटलमेंट की, एक कॉम्प्रोमाइज की कोशिश की गई थी कृष्ण जी के द्वारा. तो इसमें महाभारत का जो पूरा एपिसोड है, इसको रामधारी सिंह दिनकर ने अपनी एक बहुत सुंदर कविता याचना नहीं अब रण होगा, इसमें डिपिक्ट किया है. ये इतनी सुंदर कविता है, काफ़ी लंबी है, लेकिन इसका कुछ अंश जो विच इज़ रेलिवेंट टू द प्रेजेंट कॉन्टेक्स्ट मैं आपको सुनाना चाहता हूँ. इसको अगर आप ध्यान से सुने, यू विल फील दैट कवि ने, रामधारी सिंह दिनकर ने ऐसे वर्ड्स का चयन किया है which in itself shows that how important the mediation, the process of settlement is. So it says, जब ये पांडव 13 वर्ष का वनवास काट के जब वापस आए थे, it goes like this: वर्षों तक वन में घूम घूम, वर्षों तक वन में घूम घूम, बाधा विघ्नों को चूम चूम, सह धूप धाम पानी पत्थर, सह धूप धाम पानी पत्थर, पांडव आए कुछ और निखर. सौभाग्य न सब दिन सोता है, देखें आगे क्या होता है. अब इसके बाद कवि कहता है, जैसे कृष्ण जी वहां गए थे पांडवों का संदेशा लेके हस्तिनापुर, वर्ड्स आप देखें कि कवि ने क्या चूज किए हैं. मैत्री की राह बताने को, मैत्री की राह बताने को, सबको सुमार्ग पे लाने को. अब वर्ड यूज्ड इज सुमार्ग. काफी सारे मार्ग हो सकते थे उस प्रोसेस को, उस डिस्प्यूट को रिजॉल्व करने के, लेकिन कवि ने जो वर्ड यूज किया है सुमार्ग, that this is the best mark, this is the best process, best method to resolve the dispute. It says, मैत्री की राह बताने को, सबको सुमार्ग पर लाने को, दुर्योधन को समझाने को, भीषण विध्वंस बचाने को, भगवान हस्तिनापुर आए, पांडव का संदेशा लाए. अब क्या कहते हैं, दो न्याय अगर तो आधा दो, दो न्याय अगर तो आधा दो, पर इसमें भी यदि बाधा हो तो दे दो केवल 5 ग्राम, तो दे दो केवल 5 ग्राम, रखो अपनी धरती तमाम, हम वहीं खुशी से खाएंगे, परिजन पर असी न उठाएंगे. तो कृष्ण जी मतलब उसमें पांडवों का जो संदेशा है वो ये ला रहे हैं कि अगर आप 5 ग्राम भी, इससे बढ़िया सेटलमेंट क्या हो सकती है, अगर आप 5 ग्राम भी दे दोगे तो हम वहीं खुशी से रह लेंगे और अपने कजन्स पे, अपने परिजनों पे अस्त्र नहीं उठाएंगे, परिजन पर असी न उठाएंगे. दुर्योधन वो भी दे न सका, दुर्योधन वो भी दे न सका, आशीष समाज की ले न सका, उल्टे हरि को बांधने चला, जो था असाध्य वो साधने चला. जब नाश मनुज पर छाता है, जब नाश मनुज पर छाता है, पहले विवेक मर जाता है, जब नाश मनुज पर छाता है, पहले विवेक मर जाता है. ये काफी लंबी कविता है जिसमें कृष्ण जी उनको, दुर्योधन को और हस्तिनापुर में सभी को समझा रहे हैं. मैं आई एम नॉट गोइंग इनटू दैट, बस लास्ट वाला पोर्शन जब दुर्योधन नहीं मानता तो कृष्ण जी क्या कहते हैं. हित वचन नहीं तूने माना, हित वचन नहीं तूने माना, मैत्री का मूल्य न पहचाना, तो ले मैं भी अब जाता हूँ, तो ले मैं भी अब जाता हूँ, अंतिम संकल्प सुनाता हूँ, याचना नहीं अब रण होगा, जीवन जय या की मरण होगा, फण शेष नाग का डोलेगा, विकराल काल मुंह खोलेगा, दुर्योधन रण ऐसा होगा फिर कभी नहीं जैसा होगा. भाई भाई पर टूटेंगे, विष बाण बूंद से छूटेंगे, वायस श्रृगाल सुख लूटेंगे, सौभाग्य मनुष्य के फूटेंगे, आखिर तू भूषाई होगा, आखिर तू भूषाई होगा, हिंसा का पर दाई होगा. तो कृष्ण जी ने कहा कि उसका एंड, तेरा एंड यही होगा कि बाद में तू मिट्टी में मिल जाएगा और साथ में बाकियों को भी मिला लेगा, और इस सारी हिंसा का दायित्व तुझ पे होगा. सो what emerges from all this is the importance of amicable settlement between the parties. As legal aid panel lawyers, I request you to sharpen your emotions of compassion and empathy while you are deputed in the front offices of District Legal Services Authority. Dear friends, अभी recently हमारी नालसा की मीट हुई थी. Honorable Executive Chairperson of NALSA, he has mandated that all District Legal Services Authority should have a front office. that process was also started. Most of you must be knowing that in Patiala House, we had say created a front office, and it was about to be inaugurated, but because of certain reasons, it could not. Lekin all of you would be deputed in that front office, or these all these front offices, they have to be manned by front office coordinators, and you panel lawyers, you all know that this would be the first point of that front offices would be the first point of interaction between the legal aid seekers and our authority. एंड सारी हमारी अथॉरिटी की बागडोर आप लोगों के पास है. Needless to say that on behalf of authority, it is you who would be talking to that legal aid seeker. So I implore that you, at that very point of time, see and explore the possibility of an out-of-court settlement and advise the person accordingly. अभी जैसे मैंने ये 2 एपिसोड्स रामायण और महाभारत के बताए, उसमें रामायण में रावण ने एक पोजीशन एक्वायर कर ली. दैट पोजीशन, इट इज़ नॉट बिकॉज ऑफ एडवाइस ऑफ सम लीगल एक्सपर्ट, लेकिन उसको अपनी शक्ति के ऊपर गर्व था, घमंड था. बिकॉज ऑफ दैट ही एक्वायर्ड अ पोजीशन. And in Mahabharata, Duryodhan has acquired a position on the basis of whatever advice was given to him by his seniors and dears, headed by his Mama Shakuni. So here, whenever any legal aid seeker comes to us, or for that matter, any person comes to us or any lawyer seeking advice, आपको पता है कि उसके केस में कितना दम है, क्या है. उसी फर्स्ट पॉइंट ऑफ इंटरेक्शन में इफ यू would tell him, तो he will not assume any position जिससे बच करना मुश्किल होगा. So अगर आप फर्स्ट अवेलेबल अपॉर्चुनिटी पे इन सारी चीज़ों को एक्सप्लोर करें कि वेदर इसकी कहानी में जो भी वट एवर ही इज टेलिंग यू, is there any chance of out of court settlement, is there any chance of mediation, is there any chance of conciliation with the other party. So I would expect or rather implore all of you to do this. So about your role, जो आपका रोल होगा, and the interplay between different processes जो adopt किए जाएंगे for this settlement, I would not speak much. As for that, we have our expert speaker with us, Shri SUDHANSHU Batra ji, who is here. So I request all of you to listen to him, and whatever your queries are, whatever your questions are, वो आप चैट पे लिखते जाएं. So at the end of the session, Shreya would put all those questions to Mr. Batra, who would be there to answer all your queries. So I wish all the very best to you. Stay safe. Thank you. Over to you, Shreya.
Thank you, sir, for your encouraging and motivating words. So, the topic for today, interplay between mediation, conciliation, Lok Adalat under the Legal Services Authority Act 1987, will be taken up over by our respect-worthy learned senior advocate, High Court of Delhi, Mr. Sudhanshu Batra. Sir has been the organizing secretary of Samadhan, Delhi High Court Mediation Center, and he continues to be the member of the overseeing committee of Samadhan, Delhi High Court Mediation Center. Sir is also on the panel of Singapore International Mediation Center and Camp Bangalore. Sir, Delhi State Legal Service Authority is privileged to have you here today and to get guidance for you on the topic. Over to you, sir.
Good evening, friends. First of all, let me thank Mr. Kavaljeet Arora and Ms. Shreya Arora Mehta for having given me this opportunity to come and address and interact with all of you. In fact, I was so mesmerized by the talk of Mr. Arora himself that I felt like listening to him a little more than speak myself. But I guess that's not his job today, so I will have to take the fort. Today's topic is an interesting topic because it talks about an interplay of mediation, conciliation, and Lok Adalat under the Delhi Legal Services Authorities Act. Mediation and conciliation have found mention in a number of statutes. In fact, more conciliation than mediation. Conciliation was first introduced or mentioned in a statute was the Industrial Disputes Act of 1947. And thereafter, in 1954, the word reconciliation was mentioned in the Special Marriage Act. The Hindu Marriage Act mentioned reconciliation in 1955 when the act came into force. In 1984, so after a gap of almost 3 decades, Section 9 of the Family Courts Act provided that in every proceeding, an endeavor should be made by family court to settle the dispute at first instance. Then comes the 1996 Act. In fact, before that was the 1987 Act of the Legal Services Authorities Act, which at that time did not mention any term of mediation or conciliation. The 1996 Act first mentioned the term mediation in Section 30. Mediation was not defined under any act. Conciliation also is not defined under any act. Then in 1987, in 2002, June, the Delhi Legal Services Authorities Act was amended, and Chapter 6A was introduced, where pre-litigation conciliation found mention. Soon after that, in July 2002 itself, CPC, through Section 89, introduced mediation, conciliation, judicial settlement, lok adalat, and so on as options to be availed of by the parties during the process of court proceedings. Pre-litigation mediation, that is, before going to court, does not find mention in CPC even today. However, in certain acts subsequently, for instance, the Commercial Courts Act does talk about pre-litigation mediation. We'll come to the understanding of mediation, conciliation, and the principles of mediation, conciliation under the Delhi Services Legal Authorities Act in a short while. In 2006, MSME Act, the Micro, Small and Medium Enterprises Act, Development Act, in Section 18 provided for reference of facilitation center, which shall either conduct conciliation in the matter to seek the assistance of any institution or center providing ADR services by referring the dispute to such institution or center. So here is the MSME Act also, which starts talking about a dispute settlement process or reference of dispute settlement. In fact, doesn't talk about the process at all. Then came 2013 introduction of mediation in the Companies Act. Section 442 provided for setting up a panel of mediators and conciliators. The procedural aspects are dealt with under the rules framed under the Companies Act of 2013. Now, of course, I have a lot to say even about those provisions, because, for instance, the Companies Act mentions about filing objections to the settlement, which actually is not the real spirit or the real process of mediation as it is followed all over the world, including India. We'll come to that later. Then in 2013, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, in Section 10, provides that Internal Complaints Committee may start conciliation proceedings for the settlement of the matter between the victim and the respondent. The Real Estate Act in 2016, in Section 32G, provides for amicable dispute settlement mechanism between promoters and allottees through Dispute Resolution Forum. In 2018, the Commercial Courts Act for the first time introduced pre-litigation mediation. In fact, not for the first time, because the Legal Services Authorities Act had already amended in 2002 and introduced pre-litigation conciliation is what they call. They don't talk about mediation. In the Commercial Court Act uses the term mediation, pre-litigation mediation in section 12A. Then in 2019, the Consumer Protection Act in section 37 also provides for reference of disputes to mediation cell attached to each district, and chapter 5 of the act talks in detail about the mediation process. Now, since there is no definition that describes what is mediation and what is conciliation, now there are two different terms. Obviously, these two different terms have some difference. They are used interchangeably very often, but there has to be some difference. If there are two terms, there have to be some different meaning attached to them. First, let us understand what is mediation. Mediation is defined as such: a voluntary, party-centered, structured negotiation process conducted by a neutral third party who uses specialized communication and negotiation techniques to assist parties in resolving their disputes. It's a very long definition, and within this definition, the entire spirit or the meaning behind mediation is captured. First and foremost ingredient of mediation is that it's a voluntary process, meaning thereby there is no compulsion, there is no force, there is no method of adjudication. Therefore, mediation falls into the branch of alternative dispute redressal mechanism. In fact, I personally don't appreciate calling alternate dispute. I'd rather call it appropriate dispute redressal mechanism, because mediation actually achieves for the parties the true justice, which looks at their interests, their needs, their immediate and future long-term interests, which is completely withered away or wiped out in the adjudicatory system. So the most important aspect is the voluntary process. Then the second aspect is it's a party-centered, structured process, negotiation process. When we say party-centered, it means the participation in the process is more of the parties than of their representatives. Representatives in the form of lawyers or authorized representatives of the companies, etc. Usually in the adjudicatory system, in the conventional system, the lawyers represent the parties. The parties are not allowed to speak in court. The lawyers don't encourage them. The courts don't encourage them for various reasons and for good reasons. And the parties often get this feeling of dissatisfaction that they have not been heard, because they would like to say much more than they feel their representative has communicated to the court. That dissatisfaction creates a lot of emotional turmoil. It creates a feeling of uncertainty. It creates a feeling of dissatisfaction as to what the ultimate result is going to be, because they feel that they have not been able to say what they are aggrieved about, may it be the plaintiff or the defendant, the petitioner or the respondent. Now, mediation process allows the parties to speak as much as possible because the entire process is completely confidential. In fact, I would say that alternate dispute redressal mechanism, particularly mediation, is part of the judicial process. I don't call it a process which is outside the court. I call it a part of the judicial process because it finds mention in the most important procedural statute that governs litigation between the parties, which is the Code of Civil Procedure. Mediation is a structured process in the sense that there are stages when mediation commences. There are stages of how the mediation process is taken further by the mediator. There are stages of how the mediation process ends successfully or unsuccessfully. There are processes of how, even after culmination of a mediation process successfully, how it is again becomes an enforceable agreement between the parties. So each stage has a meaning. Each stage has some element, some effect. Although that structure is not as rigid as we find in the Code of Civil Procedure. You are all aware that the Code of Civil Procedure lays down a structure of how a litigation institutes a suit. A plaint is filed, the other parties issued summons, called upon to answer what is said in the plaint. The other side gets an opportunity to file the written statement. Replication is filed. Documents are filed by the parties. Parties are given an opportunity to admit or deny each other's documents. Issues are framed. The plaintiff is put to trial. The other side is allowed to cross-examine the witnesses of the plaintiff. The defendant is put to trial. The other side is allowed to cross-examine the defendant's witnesses. The matter is placed before the court for final hearing based on the material collected by the parties in the process, in the structured process that is given by the Code of Civil Procedure. The material in the form of documents, the material in the form of oral evidence, the material in the form of proof of documents, and so on and so forth. Apart from collating all the facts, the questions of law that emerge from those facts are finally argued at length, and the judge pronounces judgment. The judgment is pronounced in favor of one person and against the other. One wins, the other loses. In mediation, there is a structure. The structure is not as rigid, and I'll come and explain to you what is the structure in a short while. That structure is flexible enough that you can shift the third stage to the second and the second to the third. It's not necessary for you to follow each stage as it comes, because each stage will depend on the conduct of the parties, on the responses you get from the parties, on the circumstances of the case, on the kind of case that is before the mediator, that is before the parties to resolve. And therefore, that structure necessarily needs to be followed, but also in a flexible manner, because the goal of that entire structure is to focus on the interests of the parties. Now we say that the mediator, who's a neutral third party, he conducts mediation, he or she conducts mediation or conciliation. And he uses specialized communication and negotiation skills. Now, during the training of lawyers as mediators, we go quite detailed into what are those specialized communication and negotiation skills. Everybody knows what communication is. Everybody knows that if I'm speaking, you're listening, I'm communicating, and you're listening. But there's much more that goes into communication. And those skills have only one object in mind. Those skills that are used, the communication skills and the negotiation skills that are used by the mediator after being trained, have one thing in mind. You see, the parties have underlying interests which often don't surface during litigation. The parties have underlying emotions which don't come up during litigation. The parties have inter se relationship issues which don't come up during litigation. The parties forget that they are to assess what is best for them based on their present interest and the long-term interest, rather than a dispute that has arisen in the past. The parties are made to understand through those communication and negotiation skills of the mediator that all these will ultimately result in settling their disputes once and for all. The mediator does not suggest. The mediator does not decide. The mediator does not compel the parties to take a particular decision one way or the other. The mediator keeps the entire option of settlement in the hands of the parties themselves. And when the parties realize what is in their best interest for the present and the future, they automatically accept some, they give up some issues and they accept some issues. You see, one thing we always tell the parties, that here you have the power. That is why we call the communication skills of the mediator, the negotiation skills of the mediator, basically act to empower the parties to take their decisions. And we tell the parties that this is one forum that gives you an opportunity to write your own judgment, rather than seek a judgment from a third neutral party who will be dependent upon the material that is before the court, the evidence that is before the court, the law that has to be applied to those facts that are before the court, without looking at what your relationship issues are and what your long-term interests are. Because the judicial approach is to apply the law to the given facts and circumstances, and whatever the judgment the court pronounces will be a judgment that will decide a dispute of the past. For instance, a suit is filed in 2005, adjudicated in 2020. Sometimes the result of that suit does not even have any benefit for even the winner. And so winner is also a loser, and the loser remains a loser. So the ultimate aim of the mediator in applying those specialized communication and negotiation skills is to focus on the interest of the parties and their relationships for the present and for the future. Now, this is as far as mediation is concerned. Now, what is conciliation? Conciliation also follows the same process with a slight difference. The first difference is that a conciliator comes into the picture before the parties approach the court. Meaning thereby, before the parties initiate any legal proceedings against the other, they have an opportunity to apply to an institution and which carries out ADR activities, or to an individual person, requesting that person to act as a conciliator. That the conciliator issues a letter to the other side, inviting that person to participate in conciliation with an attempt to resolve the differences that have arisen between the parties. So conciliation is a process that is at the pre-litigation stage. Therefore, often the statutes reuse the term pre-litigation mediation. For instance, the Commercial Court Act uses the word pre-litigation mediation. Pre-litigation mediation is nothing but conciliation. You see, mediation has not, the process of mediation has also not been defined under any statute. Apart from the fact that the definition of mediation and conciliation is not there, even the process of mediation is missing. The only statutes that do have the process to a certain extent, one is the Arbitration and Conciliation Act 1996. Part 3 of the said act lays down the entire chapter, the entire part on conciliation proceedings. And I'll come to that in a short while to explain what is that process and how is it different from the conciliation process that has been captured in Chapter 6A of the Legal Services Authorities Act. Now, before that, the other aspect of conciliation, as I said, one is that it is a process that commences before either party approaches the court initiate any legal proceedings. The other aspect of conciliation, the difference between conciliation and mediation is that conciliator, because he's a third neutral party, acceptable to both the parties before they enter into court, there is an element of trust that is presumed right at the inception. So the conciliator has the power or the authority to even suggest possible solutions to the parties. Now, this aspect is extremely important. The reason why I say this is that when a mediator is conducting his proceedings, he has to be completely independent, completely neutral, completely impartial. So there are no element, so there are no words, no language, no signs that are made by him that create any doubt in the minds of the party of any bias, of any prejudice that he is showing in favor of one party against the other. You see, any mediation process that has to go through has to be based on trust. And to develop that trust, it's important that the mediator uses those specialized communication techniques to create that utmost trust in the parties so that the trust is maintained right till the end or the conclusion of mediation and even thereafter. Here in conciliation, that element of trust is already there right at the beginning because the parties have chosen to approach a third neutral party by mutual consent, either directly or through an institution, and therefore they are themselves have volunteered to repose faith and trust in that third neutral party. Now, when they do that, the likelihood of bias is going to be far less. The likelihood of prejudice is going to be far less. At the same time, it doesn't mean that the bias and prejudice is going to be completely wiped out because you're a conciliator. So therefore, even while suggesting options, the conciliator has to be extremely careful of the language that is used, of how it is communicated, so that the other side does not feel offended or does not feel threatened by that suggestion or an option of a possible settlement. So these are the only two main distinctions between mediation and conciliation. By and large, otherwise, the process of mediation remains the same. Now, if you look at the process of mediation, mediation has several stages. When the parties are before court, the court sees that there are elements of settlement, and that the matter is such, that the disputes are such, that the parties can settle. The elements of settlement exist. The court tells the parties the benefits of mediation, encourages them to opt for this process, and the parties are relegated to the mediation center. Then comes the second stage, and that is when the mediator introduces himself and the parties, and introduces the parties to himself and to each other, and then explains the entire process. That is the time when the mediation has the first opportunity to start interacting and communicating with the parties with an idea to build trust. The third stage, of course, the first stage must also talk about not only the benefits of mediation, but also the fact that the entire process is going to be confidential and that nothing is going to be leaked out to anybody. The courts also do not call the mediator to ask as to what happened, because in case the mediation is unsuccessful, the parties go back to the court for continuing the suit from where it was sent. Then the third stage comes of gathering information. That's the time the mediator stops talking and starts listening. Because the mediator's attentiveness to listen to each party, maintain the decorum, allow one party to speak at a time, will ultimately help the mediator focus and understand the underlying differences. During the process of gathering information in a joint session, the parties vent out a lot of their feelings. So the emotional factors that are responsible or result from the dispute surface before the mediator. Their underlying interests between the parties surface before the mediator. The mediator gets all the information from them, then decides to speak to the parties separately. In that separate meetings, a lot more is said by the parties to the mediator because the parties are hesitant to say all in front of the other side. That's the time the confidentiality process again triggers in, where the mediator must keep confidential all information that he or she possesses during information gathered at the separate sessions. After the third stage, when information is gathered through joint session or the separate session, then the mediator now realizes and starts identifying the problem between the parties. Because the parties tend to speak a lot. The parties tend to speak more than what the problem is. But gradually starts identifying the issue and clarifications are sought. And then once again, a statement from the parties is sought to seek the resolve that they would volunteer to find a solution. Once the focus, the issues between the parties are crystallized, then the real conflict is narrowed down. And those conflicts ultimately are put to the parties, and the parties are told to generate options to find a solution. That is yet another stage of mediation. The parties generate options, and then those options are placed with the permission of one party in place of the other. And when those options, the points of those options that are common are put aside, and only those points that are in disagreement are again put to the parties, and through the brainstorming sessions, find out alternative possibilities of arriving at a solution. And if a solution is arrived at, the same is reduced into writing. After it is reduced into writing, parties sign, then the mediator signs, the agreement is sent to the court examines the agreement, sees that it satisfies all the principles of Order 23, Rule 3 CPC, and then passes an order and the mediation settlement merges into the court order and is ultimately enforceable like a decree or an order of the court. In fact, more or less like a consent decree and order, and no appeal can be filed by either side. Now, conciliation, as I said, also follows by and large the same process, except that the conciliator has an opportunity to suggest options for a settlement. Now, the interplay between mediation, conciliation, and Lok Adalat came in once, if you remember, during Afcon's judgment of the Supreme Court. The Supreme Court rewrote the provision of Section 89 of CPC. Now, to my mind, that did create a little bit of a confusion, and that confusion still exists. Section 89 of the Code of Civil Procedure talks about settlement of disputes outside the court, where it appears to the party, to the court, that there exists elements of a settlement which may be acceptable to the parties. The court shall formulate the terms of settlement and give them to the parties for their observations. And after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitration, conciliation, judicial settlement, including settlement through Lok Adalat and or mediation. Now, subsection 2 of Section 89 says, where a dispute has been referred for arbitration or conciliation, the provisions of Arbitration and Conciliation Act 1996 shall apply as if the proceedings for arbitration and conciliation were referred for settlement under the provisions of that act. So as far as arbitration is concerned, there is no difficulty. There is a statute, and it has to be dealt with under that. Then B says, where a dispute has been referred to Lok Adalat, the court shall refer the same to the Lok Adalat in accordance with the provisions of subsection 1 of Section 20 of Legal Services Authority Act. And all other provisions of the Act shall apply in respect of the dispute referred to Lok Adalat. So as far as that is also concerned, Lok Adalat has set out certain procedures which I'm going to discuss in a few minutes. Then the third is C, which says, where a dispute has been referred for judicial settlement, that's C, the court shall refer the same to a suitable institution or person, and such institution or person shall be deemed to be Lok Adalat, and all the provisions of the Legal Services Authority Act shall apply as if the dispute were referred to Lok Adalat under the provisions of the Act. And D says, for mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. Now, there is no procedure prescribed. So Section 89 provided an opportunity for the courts to set out certain rules under the to be followed by the mediation centers which are annexed to the court. So the mediations are referred to those centers. Now, in Afcon's judgment, the Supreme Court felt that Section 89 should be reworded so as to interchange Clause D of subsection 2 with Clause C and Clause C with Clause D of subsection 2 of Section 89. Meaning thereby that for mediation, so the provision was rewritten and it read, where a dispute has been referred for mediation, the court shall refer the same to a suitable institution or person, and such institution or person shall be deemed to be a Lok Adalat. Now, instead of judicial settlement, it was replaced by mediation. Now, mediation will be referred to an institution, and such institution shall be deemed to be Lok Adalat, and all the provisions of the Legal Services Authorities Act shall apply. And D the term mediation in D would be replaced by judicial settlement. That judicial settlement will be affected by the court. Now, this creates, to my mind, a huge difficulty, because Chapter 6 A of the Legal Services Authority Act deals with pre-litigation conciliation and settlement. The entire act does not even talk about any process of mediation. If you carefully look at Chapter 6 of the Legal Services Authorities Act, you will see that what kind of disputes can be referred to such Lok Adalats. Those Lok Adalats are those that are organized from time to time by every state authority or district authority or the Supreme Court Legal Services Committee or every High Court Legal Services Committee or the Taluk Legal Services Committee. So that is not, it's not a permanent, the Lok Adalat is not of a permanent nature. It is a Lok Adalat that is organized by these committees from time to time and at such convenient place that the committee deems fit. Now, what kind of cases can be referred to these? And what are the powers? What is the process under this Lok Adalat? Any case pending before any court for which the Lok Adalat is organized. So any case which is pending before any court for which the Lok Adalat is organized can be referred to this Lok Adalat. Or any matter which is falling within the jurisdiction of and is not before any court for which the Lok Adalat is organized. So any matter which falls within the jurisdiction. So what is the jurisdiction? The jurisdiction is one, not non-compoundable cases. There can be compoundable cases, and there can be cases with the subject matter of the dispute is up to 10 lakhs, which is now enhanced to 1 crore. Now, once these kind of cases are referred to the Lok Adalat, which is organized by these committees, the Lok Adalat is supposed to take cognizance under Section 20. Now, the moment we use the word cognizance, cognizance is power, authority, or ability to determine. Now, this power of the Lok Adalat is to determine whether there is a settlement that is possible or not. Period. This cognizance is only to determine whether there is possibility of a settlement between the parties or not. In case there isn't, then the matter is referred back to court. And in case there is, the settlement is reduced to writing and becomes an award. An award is passed by the Lok Adalat, and that award is enforceable like a civil court decree. And when those categories of cases that are referred to mediation, which are not brought before the court, which are referred to Lok Adalat, not mediation, and are within the jurisdiction of the Lok Adalat, where settlement is not possible, the parties are advised to seek whatever legal remedy is available. So you see, this Lok Adalat is not actually performing a conciliation process. Of course, they need to persuade the parties to settle. And the principles on which they are guided to persuade is principles of justice, equity, fair play, and other legal principles. So here we are not talking about the wishes of the party. Here we are not talking about underlying interests. Here we are not talking about relationships. Here we are not talking about present interest and future interests. So settlement happens. If the Lok Adalat is of the view that the settlement should happen, it will try and persuade the parties to settle. If no settlement happened, this is the process that is to be followed. Now comes another chapter, which is 6A. Chapter 6A deals with pre-litigation, conciliation, and settlement. In Afghan's judgment, mediation is to be referred to an institution which is deemed to be Lok Adalat, and all provisions of Legal Services Authorities Act will apply. So that means in that case, mediation will also be like conciliation, because conciliation is what is envisaged in Chapter 6A. Now, if you look at this permanent Lok Adalat, has exercises such jurisdiction in respect of one or more public utility services, or for such areas as may be specified in the notification. So essentially, the permanent Lok Adalat is really up to is to look at only the permanent Lok Adalat is only look at to exercise jurisdiction over disputes relating to public utilities. I'm sorry, I think I wrongly mentioned the earlier Lok Adalat, which is organized under Chapter 6, does not lay down any jurisdiction in terms of pecuniary jurisdiction. It is a permanent Lok Adalat that has jurisdiction up to 1 crore now. The Act says up to 10 lakhs, which is now gone up to 1 crore by a notification. So the conciliation process that is envisaged in Chapter 6A is all based on the same principle as that which is laid down under Chapter 6 of the Legal Services Authorities Act. That is the principle of justice, equity, fair play, and so on. Here also, the process does not talk about addressing interests, addressing relationships, understanding the wishes of the parties, understanding the underlying conflicts, and so on, and is only to see whether a settlement is arrived at. Now, unfortunately, I would say unfortunately, because permanent Lok Adalat is also given adjudicatory powers in case parties don't settle. So the Chapter 6A really makes it mandatory for the parties to participate in the Lok Adalat, the permanent Lok Adalat. And this, it can be triggered off by an application by any one party. The information is said, the party is supposed to give a written statement of its grievances in terms of facts, the grounds, and so on and so forth. The other side is expected to file reply, and so on. Now, although they are not bound by the Code of Civil Procedure and the Indian Evidence Act, but yet the Lok Adalat, permanent Lok Adalat, has the powers to decide a dispute in case the parties don't settle. Now, this is not what is envisaged in the true conciliation process that is envisaged even under the Arbitration and Conciliation Act of Part 3. Part 3 is the Arbitration Conciliation Act that deals only with conciliation. So you see the difference of the entire concept of conciliation under the Legal Service Authority Act and the process that mediation and conciliation follows in facilitating the parties or helping the parties has created a lot of confusion as to whether Lok Adalat, the permanent Lok Adalat, really performs the conciliator's role as it ought to be in terms of what conciliation is. Now, if you quickly look at, I won't take much time because I think it's almost 4 o'clock. If you quickly look at Part 3 of the Arbitration and Conciliation Act, where the scope of the applicability is all sorts of cases arising out of legal conciliation of disputes arising out of legal relationships, whether contractual or not, and to all proceedings relating thereto. So unlike the permanent Lok Adalat, which has a limited jurisdiction of one, public utilities, pecuniary jurisdiction up to 1 crore, only compoundable offenses, not non-compoundable offenses, and so on. Here you have unlimited scope of the kind of cases that can be referred for conciliation. Now the process is very simple. One of the parties approaches either a conciliator or an institution and seeks appointment of a conciliator for dispute between two parties or even more than two parties. There can be one conciliator, there can be two conciliators, there can be three conciliators. The parties are free to decide If they are unhappy with one conciliator, there can be two conciliators. Now, once the parties make their submissions, and of course, this act also uh, 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 obliges parties to give written statements and exchange their grievances and exchange it with the conciliator and file response thereto. But there is one provision where, under the role of conciliator, the parties can uh, uh, request the conciliator to take oral statements. So, as far as the Delhi High Court Mediation and Conciliation Center is concerned, we do not invite parties to give anything in writing because we would like to maintain the confidentiality and keep no documents on record lest they are at any time misused. Now, the role of the conciliator is to assist parties. Of course, the principles are more or less the same, but here, in fact, the principles are about the fair play, justice, equity, and so on. Apart from that, the wishes of the parties becomes important. If you see subsection 3 of section 67, it deals with the wishes of the parties may express, including any request to the conciliator that any oral statement be given. So here, a lot of stress is given because it's a party-centered process. And I don't see in the Legal Services Authorities Act, the Permanent Lok Adalat, has any element of the process being too much party-centered process. Once the proposal is made, then the parties reduce that into writing. Now here comes, if the settlement is arrived at, that is again drawn up in the form of an agreement, which is called a conciliated settlement agreement. That agreement has the force of an award under the Arbitration and Conciliation Act. Section 74 uses the words, the conciliated settlement has the same status and effect of an arbitral award. So therefore, enforceability of a mediated, of a conciliated settlement is as good as getting an arbitrator's award. And you know how an arbitrator's award is to be enforced under Section 36 of the Arbitration and Conciliation Act 1996. Now, this chapter also very specifically at two places talks about confidentiality. Section 75 of the Arbitration and Conciliation Act talks about maintaining complete confidentiality. And Section 70 of the Act talks about not parting with any information which is given in private secretly by one party to the conciliator. And the conciliator will not part with that information. So it talks about confidentiality both under Section 70 and 75 of the Arbitration and Conciliation Act. Now, if you broadly look at Chapter 6, 6A, and the Arbitration and Conciliation Act Part 3, you will see that there is a complete different process that is envisaged for conciliation. And therefore, this conflict, I think, needs to be removed by the legislatures by appropriate amendments. Of course, the courts have come into our rescue of the parties a lot of the times. When they see this kind of a inconsistency, they harmonize it in the interest of the parties. But this confusion has really created a lot of issues, and this, I think, must be resolved. So this is as far as the interplay between mediation, conciliation, and Lok Adalat is concerned. I would now invite the participants to be free to ask me any questions. I think I have overshot, so I had to quickly wrap up my last bit of my information that I wanted to share. Shreya.
So yes, of course, we have a lot of questions already. I would remind each of the participants to please write your questions in the chat box so that it reaches us. And I'm going to put the questions to the learned resource person one by one. In case I miss any question which you asked like 20 minutes back and you feel I'm not covering it, please copy that question and paste it again. So we start with the first question. Okay. So this is Manisha Shocking. She said, matter settled after interim order, matter disposed due to settlement, but again dispute raised. Can we file the execution in the compliance of interim order despite settlement was suggested about the interim order?
Yeah. Manisha, I think what you're trying to say that after the interim order was passed, the matter was referred to mediation and the parties entered into a settlement. And that settlement went to court. If the court has passed an order in terms of the settlement and disposed of the entire list, entire suit, then you're absolutely right. Execution can be filed because it becomes an executable order or a decree depending on the kind of matter in which the parties were referred to mediation. Because this is interesting, and I'd like, in fact, like to point out a very interesting case. And Section 9 of the Arbitration and Conciliation Act was pending, which is talking about interim orders. And that case was referred to mediation. The parties settled, and the mediation agreement contained a clause that the court may be requested to pass a decree. And the court passed a decree. Now, the question is, can a decree be passed under Section 9? Obviously not. Section 9 is an application for interim measure under the Arbitration and Conciliation Act. So there was a breach of by one of the parties. So when the party went for execution, the executing court felt that it should not have been a decree and it's like an award, and therefore passed an order asking the parties to go seek remedy under the award, because this is an award since it's a settlement under the Arbitration and Conciliation Act. Now the party went and filed execution under Section 36 in the relevant jurisdiction, territorial jurisdiction. Then the question came up after 1.5 years, because this order of the court telling the parties it's an award was challenged before the division bench. Be careful of what orders are passed once a settlement is sent to the court for its enforceability later. It culminates into an order or a decree. So that the lawyers need to take care of.
And the next question. Sir, does the mediator has any obligatory duty to tell and explain the law regarding the matter?
Well, as I said, the mediator doesn't advise. The mediator does not suggest. If the mediator feels that the party is not on the right track as far as law is concerned, I think the mediator should encourage the parties to examine this aspect with the lawyer. The mediator is free to have separate meetings with the lawyer and ask the lawyer to examine this proposition of law and help the parties take the correct advice rather than suggesting himself.
So the next question is by Manu Gupta. Can arbitration proceedings go to Lok Adalat?
It talks about courts. So technically speaking, arbitral tribunals are not courts. If you look at Chapter 6 of the Legal Services Authority Act, it talks about two kinds of cases. One, it says any matter, it says any, just one second. It mentions in section 19, subsection 5, says that 5.2, it says any case pending before any court for which the Lok Adalat is organized, or any matter which is falling within the jurisdiction and is not brought before any court for which the Lok Adalat is organized. So it has to be the court that can send the matter to Lok Adalat, not the arbitration.
So the next question is by Mr. Charanjit. He says, if a mediator is performing his or her duties in impartial manner, what remedies are available to the aggrieved party? I think he means
yeah, the aggrieved party can immediately walk out of the mediation and terminate the mediation process. And that is also explained by the mediator in its opening statement in the beginning, that you're free to walk out anytime you feel that the mediator is being prejudiced or biased.
Okay. This is a basic, I think Mr. Ram Kishan has put, can settlement may contain clause contrary to law? I think.
Mr. Ram, obviously it should not, but if it does, as I said, a mediation settlement, when it goes to court, the court has to see and examine that the settlement satisfies all principles of Order 23, Rule 3, which inter alia also includes that the settlement is legal, tenable in law, enforceable, and that it can be, it's valid in law.
So then this is a question by Advocate Ram Kumar Soni and Mr. Scott. This
When
is
the
when
matter is being referred to
the matter
mediation,
is
it is
been referred
ultimately
to mediation and is amicably settled. Thereafter, that's it. I'm gonna. So
the
I'm
full
gonna.
question is not coming.
It's not full. What are
I
the
can't see the full question.
so this is my next Anupama Gupta. What are the qualifications required for the formal appointment of a mediator and conciliator? I am asking this question because once I heard of mediator confessing, I am least aware of more.
Anupama, qualifications of the mediators are prescribed under the rules framed by various court centers in exercise of the powers under Section 89. And each center has its own, but more or less, the powers are that you must have a 5 years standing at the bar, you must undergo training. The Delhi High Court Mediation Conciliation Center insists that the training is only through the mediation center, that's the Samadhan, and outside trainers will not be accepted, and that you must be a member of the Delhi High Court Bar. But I think there is a certain amount of flexibility to this as far as the other court annex centers are concerned. But yes, this is the basic qualification. And for a conciliator, under Part 3, if you Part 3 of the Arbitration and Conciliation Act, or any other part where an arbitrator is to be appointed, there is no qualification for an arbitrator prescribed. And even for a conciliator, if you look at Part 3, there is no qualification that is prescribed. And there are no rules. So anybody can be an arbitrator, and anybody, if you have trust in that person.
Right. So next question is by Mr. Ravish Dua. Can a statement given in mediation deed be later used in evidence?
See, once a mediation deed or mediation settlement, I wouldn't call it deed, has been accepted by the court has passed an order, that becomes judicial record. So any part of that can, of course, be used after the settlement is arrived and the court has passed the order, disposed of the matter in terms of the settlement.
So next is by Labhanya Sharma. Is it the duty of the mediator to explain to the parties the legal strength and weakness of their respective case?
Lavanya, I think it's a very good question you're asking. But again, we go back to the basic role of a mediator, is that cannot advise, cannot suggest, but in order for the parties to examine the strengths and weaknesses of the case, they must empower the party to do it. And that's the skill that the mediator must develop. The skill is not the power to decide. The skill is to empower the parties and empower the parties to examine the strengths and weaknesses of the case. And when you feel that the legal assistance is required, they must seek the participation of lawyers who are representing the parties. And therefore, we also encourage lawyers to participate in mediation so that they help them examine the strengths and weaknesses of the case. Yes, we have come across instances where lawyers have, for ulterior reasons, not correctly given the strengths and weaknesses of the case, but 99% of the cases, we don't find such situations. In rare case, we do.
So next question by Mr. Shiven Verma. Many a times clients are hesitant to go into pre-litigation mediation conciliation. What are your suggestions to convince the client that mediation conciliation is his or her best interest?
I think the advantages of mediation and conciliation must be fully understood first by the counsel himself, so that he's able to communicate that in the right perspective to the parties. I think what is important for the parties to understand is that it is in their interest to always explore an amicable resolution rather than wait for a judge or a court to pronounce judgment after so many years. The uncertainty of the result, the time gap taken in the courts, the length of time that you spend in court, the expenses that you incur, the emotional turmoil that you go through, the ill effects on the health of a party or a litigant. There are so many reasons, there are n number of factors that you can impress upon the clients to explore the possibility of mediation and conciliation, because I feel that every counsel has to first look at the interest of the party rather than their own personal interests. And I can assure you, today I was listening to a very interesting webinar on the future of virtual courts. And one of the very interesting point that was raised by a professor of Harvard University was that we are looking at a legal profession from the perspective of our own interest, that is a professional lawyer's interest. But the end user is for whom the legal system has been enacted. So what you need to look at the interest of the end user. The interest of the end user is to ultimately get satisfaction from the result that can happen speedily, that can happen with cost-effective manner, and that can happen with less turmoil. So ultimately, then therefore, this conciliation and mediation, if not explored, in any case, the option to go to court is always open.
So then there is this question by just the advocate. There are certain matters in which mediator doesn't take interest and later on forced to settle without their interest and without listening to them. What are the steps to change the mediator?
If this is a feeling that the party or the councils are getting, and the mediator is appointed through a court annex center, I think the coordinator or the secretary of the court or annex center must be immediately approached, and a request must be made in writing or orally, so that the mediators also, doesn't feel too bad about it. The intention is not to hurt. Intention is to do something which is in best interest of the parties, and ask for a replacement. There is no problem. Mediators can be replaced.
So next is by Mr. Vinod Kumar. Is mediation settlement enforceable or not? If yes, what remedy?
Vinod, I had mentioned during my interaction that a mediation settlement, once signed by the parties and the mediator, goes to court. The court passes an order. Mediation settlement merges with a court order. So either a decree is passed or the matter is disposed of by an order. That, of course, is executable just like any civil court decree or a civil court order.
So next is by Advocate Bipin Rakesh. An agreement takes place between the parties at pre-litigation stage before a mediator at Mahila Cell, Delhi, but parties are not abiding. Such an agreement enforceable before the court?
I'm sorry, I couldn't read the whole question, but parties what?
Agreement takes place between the parties at pre-mediation litigation stage before the mediator at Mahila Cell, Delhi, but parties are not abiding now. Is such an agreement enforceable before the court?
As I said, a settlement agreement arrived at during conciliation process, which is a conciliated settlement agreement, is enforceable, has a same status and effect of an arbitral award under Section 74 of the Arbitration and Conciliation Act. Therefore, enforce it under Section 36 of the Arbitration and Conciliation Act.
Okay, true. So this is an interesting question. As you said, nothing is taken in writing form to maintain the confidentiality. What is the provision for any breach of confidentiality? This is by
Uh,
Advocate Ashwini Bali.
These are some of the areas, since mediation is not codified. Consequences for breach and all obviously are not written. Therefore, it is settled law, because even through judgments, and even through, if you look at carefully the conciliation chapter in part 3 of the Arbitration Conciliation Act, as well as the rules framed by the centers, by the court annex centers, that any document or evidence received during mediation will not be admissible in evidence in law. So even if it is used, the other side can always argue that it was obtained during the mediation process, and therefore it will become inadmissible in law. The question is not of penalizing a party for the breach. The question is, when it does not become admissible in evidence itself, then the whole purpose is achieved.
So next question is by Mr. Srivastava. If an award under Section 74 is passed, can it be challenged by any of the parties, it being a settlement akin to a consent decree?
Very interesting. A settlement, conciliated settlement, which has the same status and effect of an award. So obviously, if it has the same status and effect on award, it can also be challenged under Section 34. But the grounds of challenge will be very limited. It will be, if you look at subsection 2 of Section 34, it talks about fraud. So fraud could be one of the grounds that could be raised to challenge such a settlement. But otherwise, unless it's against public policy, the settlement. So see, with conciliated settlement doesn't go before any court, right? So to see, suppose there is a clause which is legally untenable, which is a contrary to law. Now this will be against public policy. It will be unable to challenge under Section 34. So yes, it can be challenged under Section 34.
Right. So now the next question is by Advocate Hilal Manzoor. Can a judge himself or herself act as a mediator?
Ordinarily not. But I'd like to reserve my comments on it. I'm before two very big judges in front of me.
So
Ordinarily not. Actually, in fact, because there is an element of bias that is likely to come in, so we feel that it should not. The judge should not.
So next by Advocate Satwar Singh. Settlement was done in mediation, but now due to lockdown, the party is not in a position to pay installments. What is the remedy, sir?
Settlement was done, and was it was the order passed by the court? If it was, then you have remedy of executing that order. But of course, the plea of force majeure and so on, so many pleas will now emerge. COVID-19 situation, nobody had envisaged, and I think it'll have to be dealt with for non-performance for reasons beyond the control.
True.
If there is a question of getting money and the money has not come because of COVID-19 reasons, I'm sure that Section 56 of the Contract Act could be argued, and yeah.
So we had a detailed discussion on this in the session 1. So next
Yes. Okay.
is by
Okay.
Advocate Chandar Bhardwaj. In DV Act cases, there is tendency to defy the terms of mediation settlement. Can the mediation settlement be enforced by the court in terms of Delhi High Court judgment?
Yes, it can, but depends on what you're trying to enforce. The only gray area that I've found in matrimonial disputes is that when there is a conciliated settlement to go for divorce, and divorce requires a certain process to be followed. First motion, second motion, and the parties go through the first motion, but decline to go through the second motion. Now, in that case, can the party be forced in an enforcement of a conciliated settlement to go for the second motion? Now, that will be inconsistent with the spirit of the Hindu Marriage Act, which talks about giving them cooling time and so on. Now, in that case, what we suggest is that when such like things happen, it's better to take undertakings from the parties, because the remedy of breach of undertaking is always open to the parties. That is in the form of contempt if it is mediation. But if it is not in mediation, then conciliation undertaking will have different connotations completely.
So next question is by Garvit Vinayak. Parties settle a matrimonial dispute and agree to get separated in mediation. Thereafter, statement in first motion is recorded. If either of them resiles from their statement given, what's the remedy?
I think that's exactly what I just answered. Perhaps
Oh,
that the problem is that this is a gray area, because when you're enforcing a conciliated settlement, this is a mediation settlement. So mediation settlement also, see, enforceability is question is, in fact, Justice Hima Kohli's judgment on this, that if it is a undertaking given, the courts can punish you for contempt. Undertaking recorded in the settlement, which is merged into the court order, so that undertaking will be contemptuous if it is violated. That's the best that can happen for enforceability of this kind of a settlement.
so Manisha Saneja, if arbitration award has passed, will it be treated under execution normally or under arbitration award? I think she means for
Nisha,
all.
I think an arbitration award will be executed under the Arbitration Act in accordance with the provisions of the Arbitration and Conciliation Act 1996.
True. I think family court judge, on basis of biased report of counselor, made assumption, presumption about the parties, and then judge proceeds in the case on that basis.
So, once a family court judge on the basis of biased report of a counselor, assumption.
I think this is not a clear,
No, I don't think your question is very clear.
very clear. Tarveen Singh Nanda, I would like to bring to your notice that when a legal aid matter is referred to mediation, the LAC does not get any record for his appearance. So he's unable to raise invoices for, oh, so that's for us.
I think
I
that
think
Shreya will
we will answer
Shreya,
that
I think you
question
can take this.
in one discussion. How do you foresee the future of mediation in India?
Well, I think mediation has come. It's been 15 years since it has been part of the judicial system. As Mr. Arora had rightly said, mediation has been part of our culture. It's been in India for many, many years, but finally accepted in the judicial system in 2002, when the amendment to the CPC was, Section 89 was introduced. I think mediation has a very, very bright future as long as there is sufficient awareness. What is lacking today is awareness of the general public. Ordinarily, people do not know that there is this forum that is very effective. Once the parties come to know the effectiveness of this, I'm sure they will opt to explore this possibility. In the West, there have been cases where mediators are doing lucrative business. Parties are very satisfied. But yes, there are also certain areas, even overseas, where mediation is still pro bono. But I think it's going to take time, but definitely mediation has a very, very long future and a good future in India as well.
Hmm. So this is Meenu Juneja. Can the pre-litigation mediation be made compulsory in domestic violence and family matters? Because many a times while my duty at front desk, I come across a situation that mediation is the best solution.
Meenu, I think your sentiments are well taken, but the legislatures will have to do something about this to make it compulsory for pre-litigation in DV and family matters. I remember there have been now cases earlier. 498A straight away used to be registered, but now you have to go through the whole process. So things have changed, and I think it should be made pre-litigation mediation should be made compulsory, but with appropriate legislations, I think it will be more effective.
So then there is this by Shikhar Tiwari, for which disputes is mediation appropriate and what are its advantages? Detailed.
I think many, almost all, see, disputes relating to personal rights, matrimonial, family, property, IPR, construction, infrastructure, all commercials, compoundable offenses, non-compoundable offenses, well, such as 467 and all, 498A also has been, but of course the settlement can't be that it stands quashed. You have to take permission of the court by filing a petition under section 482 of the CRPC, and the courts are encouraging such settlements. So there are very select non-compoundable cases also that have been settled. But I must say a large spectrum of cases. It's difficult to give to let you know the list right now, but we've had IPR matters. You won't believe it. Patent matters. Of course, trademarks and copyright have already been settled. A number of cases have been resolved through mediation process. Even patent matters at the pre-litigation stage have been settled. So it's a huge list.
Last question. Tanya Agarwal, can the statements recorded before the mediator be later used to confront or contradict the opposite party at the time of cross-examination of the trial?
No, it's not admissible, and that objection can be taken, and if the objection is sustained, then it is not admissible in evidence.
True. So I think there are not many questions are coming.
I know. We'll have to.
So, but
they can write if they want. They can write to me, and I can surely.
What we will do is, I would request everyone to please post.
I will answer it to the best of my ability. I am no authority, but yes, I will do it.
So now I would request our member secretary to also join.
I'm sorry for overstepping your time schedule.
No, that's completely fine, sir. So we are getting a lot of messages about thank you, it went well, and so over to you, Kamal sir.
It was really very nice, sir, having you here with us. You have valuable insights which you have given with respect to different methods of alternate dispute resolution. I think our panel and panel lawyers, they tend to gain so much from the experience which you have got, sir. And the whole of your experience which you have epitomized in this talk of yours, and the content of this talk, which has covered almost all the topics, including the quality and the qualifications of arbitrator, say the conciliator, whether they should have any or not. Arbitrator, as you said, that he does not require, he only needs to have faith of the parties in him. So the tremendous insight and the content itself shows the amount of hard work which you have put in for this talk show, sir. I, on behalf of the entire team of Delhi State Legal Service Authority, thank you, sir. Thank you for your time, for your energy, for the enthusiasm, and for all that insights which you have given to us, sir. Thank you. So nice of you. We were lucky to have you, sir, with us for this show.
Thank you, Mr. Roda. Thank you, Shreya, for all your help since yesterday. She tried to teach me technology, and I've learned a lot. Thank you.
Thank you, sir. Thank you. Thank you very much.
Thank you so much, sir.
Thank you.
Thank you.